When this case came before the Divisional Court, it failed to give proper consideration to UNHCR's evidence. That was a mistake. UNHCR has unrivaled practical experience of the working of the asylum system in Rwanda through long years of involvement there, and its evidence requires careful consideration. So the Court of Appeal was right to overturn the High Court's decision and to consider the evidence again for itself. It concluded by a majority that asylum seekers who are sent to Rwanda are at real risk of refoulement, and that the policy is therefore unlawful. The question for this court is whether they were entitled to reach that conclusion on the evidence. The Court of Appeal based their conclusion on the following evidence. First, Rwanda has a poor human rights record. In recent times, British police have had to warn Rwandan nationals living in the UK of credible plans by the Rwandan government to kill them. In 2021, the UK government criticised the Rwandan government for extrajudicial killings, deaths in custody, enforced disappearances, and torture. There are also concerns about media and political freedom in Rwanda. Since Rwanda has ratified many international human rights conventions, this evidence raises questions as to its compliance with its international obligations. It's also relevant to the question whether the Rwandan courts can be expected to act independently of the Rwandan government when deciding appeals against the Rwandan government's decisions on asylum claims. Secondly, UNHCR's evidence is that there are systemic defects in Rwanda's procedures and institutions for processing asylum claims. To mention only some of the points raised, they include, first, concerns about the asylum process itself, such as the lack of legal representation, the risk that judges and lawyers will not act independently of the government in politically sensitive cases, and the fact that the right of appeal to the High Court, which has existed in theory since 2018, has never, in fact, been exercised. Secondly, Rwanda's 100% rate of rejection of asylum claims from countries in known conflict zones from which asylum seekers removed from the UK may well come, such as Syria, Yemen, and Afghanistan, although the UK authorities often find that such claims are well-founded. Thirdly, Rwanda's practice of refoulement, of which UNHCR gave over 100 examples, which continued during the period after the UK's agreement with Rwanda was concluded. And fourthly, the Rwandan government's apparent misunderstanding of its obligations under the Refugee Convention. The third matter raised is, in UNHCR's evidence, is Rwanda's failure to fulfill undertakings which it gave to the government of Israel under an agreement for the removal of asylum seekers from Israel to Rwanda, which operated between 2013 and 2018. In terms of the agreement, asylum seekers sent from Israel to Rwanda were to be allowed to claim asylum there, and there was an explicit undertaking by Rwanda to comply with the principle of non-refoulement. The agreement was therefore similar in those respects to Rwanda's agreement with the UK. Despite the terms of the agreement, asylum seekers who were sent to Rwanda by the Israeli government were routinely moved clandestinely to a neighbouring country from which they were liable to be refooled. That evidence is not contradicted, and it raises a serious question as to whether the undertakings given by Rwanda under its agreement with the UK government can be relied on. As I have explained, the legal test which has to be applied in this case is whether there are substantial grounds for believing that asylum seekers sent to Rwanda would be at real risk of refoulement. In the light of the evidence which I have summarized, the Court of Appeal concluded that there were such grounds. We are unanimously of the view that they were entitled to reach that conclusion. Indeed, having been taken through the evidence ourselves, we agree with their conclusion. We accept the Home Secretary's submission that the Rwandan government entered into the agreement in good faith, and that the capacity of the Rwandan system to produce accurate and fair decisions can and will be built up. Nevertheless, asking ourselves whether there were substantial grounds for believing that a real risk of refoulement existed at the relevant time, we have concluded that there were. The changes needed to eliminate the risk of refoulement may be delivered in the future, but they have not been shown to be in place now. The Home Secretary's appeal is therefore dismissed. There is also a cross-appeal on behalf of one of the asylum claimants who argues that the Rwandan policy is in breach of retained EU law, as well as being unlawful for the reasons that I've already explained. We reject that argument on the basis that under an Act of Parliament enacted in 2020, the EU provisions in question ceased to have effect at the end of that year. The cross-appeal is therefore also dismissed. The Court will now adjourn.